For the next hour, we will all have the opportunity to hear directly from leaders at the SEC and the Department of Justice, a recently departed leader of the CFTC, and a world-class white-collar defense lawyer, agency's recent accomplishments and their upcoming enforcement priorities. And we're delighted to have all of you with us today. I'm Jason Linder, and I'll be the moderator. I'm the vice chair of the ABA's White Collar Crime Committee, which has had the pleasure of organizing and presenting this panel. I'm a partner at Mayer Brown and co-chair of the firm's global anti-corruption and FCPA practice. I served for 10 years as a federal prosecutor, including about half of that time working with Dan Kahn, who's also appearing on your screen, in the FCPA unit of the Department of Justice. Let me introduce everyone else. So first, I'm going to start with Stephanie Avakian. She should appear on your screen. She is the director of the U.S. Securities and Exchange Commission's Division of Enforcement. In that role, she leads more than 1,350 lawyers, accountants, and other employees. She became the deputy director of the Division of Enforcement in 2014, became co-director in June of 2017, and then has served as the sole director since her co-director Steve Pekin's departure in August of this year. Before being named deputy director, Ms. Avakian was a partner at Wilmer Hale, where Mike Leotta works now. And she there was the vice chair of the firm's securities practice. And before she was at Wilmer Hale, she had previously served as a branch chief in the SEC's New York regional office and as a counsel to former SEC Commissioner Paul Carey. Next up is Dan Kahn. He is the acting chief of the fraud section of the Department of Justice's criminal division. In that capacity, Dan supervises and manages the day-to-day operations of the section and leads the section's approximately 165 lawyers who investigate and prosecute healthcare fraud, major financial fraud, and violations of the Foreign Corrupt Practices Act. Dan has been in the fraud section for about 10 years, and prior to taking over leadership of the entire section, served as a senior deputy chief and as chief of the FCPA unit. Rounding third, we have Jamie McDonald, who has I don't know if you can see him, he has great drapes behind him. Jamie is currently a senior fellow at NYU Law School. From April of 2017 until last month, he served as the director of the Division of Enforcement at the Commodity Futures Trading Commission. Prior to joining the CFTC, Jamie served as an assistant U.S. attorney in the Southern District of New York, as a deputy White House counsel, and as a law clerk to both Chief Justice Roberts and Judge Jeffrey Sutton on the Sixth Circuit. And last but by no means least is our world-class white-collar defense lawyer, Mike Leotta. He is, as I mentioned, a partner at Wilmer Hale. He conducts internal investigations and represents financial institutions, other corporations, and individuals in matters involving criminal law, securities law, and financial institution regulations. So the whole smorgasbord that we're all going to talk about today, with a focus on the Bank Secrecy Act and related anti-money laundering rules, insider trading, and the FCPA. Like everyone else on the panel, before joining Wilmer Hale, Mike served in many distinguished positions in government, including in the White House counsel's office under President Obama, as an assistant U.S. attorney prosecuting fraud and public corruption, and as the appellate chief and ethics advisor in the U.S. Attorney's Office for the District of Maryland. He also currently serves as the national chair of this committee that's presenting this panel, so I think he's technically my boss. It's a great tie, by the way, Mike. And as co-chair of our subcommittee on financial institution fraud, money laundering, and the Patriot Act. Okay, and with that, let's dig in. We're going to start with a softball, and then they're going to get really hard. So let's begin with an opportunity to reflect on the last year. It was a year marked by unprecedented challenges for your agencies and for all of us. It was also a year in which each of your agencies can point to record-breaking accomplishments. When you look back, what are you most proud of? What will endure, either in terms of enforcement priorities or approaches going forward, even as the world hopefully emerges from the pandemic? Let me begin with you, Stephanie.
Well, thanks. Thanks, Jason. Thanks for having me. And before I get started, let me give my disclaimer that the remarks I give in my own do not necessarily reflect the views of the Commission or the Commission staff. And with that, look, there are a lot of cases and accomplishments that I'm very proud of, but I have to tell you, looking back on this past year, by far the thing I take the most pride in is the way that everyone in the enforcement division responded in the wake of the pandemic. And that is far and away, what I am the most proud of. I mean, folks, and we're like everyone else in the country and in the world, in the sense that everyone had their personal lives turned upside down. Everyone had their professional lives turned upside down. Everybody went to becoming school teachers and caregivers and all kinds of other things and dealing with illnesses and worried about illnesses. And, moving a 1,400 person ship to telework overnight, almost literally overnight, is quite a feat. But the fact that, everybody managed to figure out how to juggle the stuff, how to work together as a team, how to keep rowing in the same direction. When I look at what we accomplished then as a division and an agency, when you do think about the cases and the relief and what we managed to accomplish in the wake of all that, it's just astonishing to me. So for me, I take by far the greatest pride in the staff. And, obviously lots of great cases, which we'll talk about, I think, as the night goes on a little bit more. And the only other thing I'd point to, I know you only asked for one thing, but I'm going to give you another one, which is we made some pretty dramatic improvements in the efficiencies in our whistleblower program. And I think that when you look at the amount that the commission has paid out to whistleblowers and the number of awards that we've paid out in the last year, it eclipses what we've been able to do before now. And I only expect that to continue. And we take great pride in that as well. So thank you.
Thanks, Stephanie. And we will come back to the whistleblower program, and I'll be excited to hear about the efficiencies and what's going to happen in the future, but we'll come back to that. Let me turn to Dan, who I guarantee will not have only one thing to talk about. Go ahead, Dan.
Probably true. My answer is actually going to sound a lot like Stephanie's, including the part where she said the views that she expressed are not those of her agency. And so I'll get that out of the way. The views are my own and not those of the DOJ. But wholeheartedly agree with Stephanie. I think given where this year started, or at least, where it seems in all of our memories, where it started back in March when the pandemic hit, it's truly remarkable to see how, obviously around the world, how everyone is responding in general, but certainly the prosecuting offices, the fraud section prosecutors, to be able to do the job that they've been doing and continue to bring righteous and just cases despite everything else going on is nothing short of remarkable. And so, we certainly had a number of things happen before the pandemic hit where, we convicted the former Minister of Industry of Barbados for laundering proceeds of bribery through a dental office in Long Island. The Airbus resolution, which was one of the largest coordinated resolutions in any foreign bribery case. But then to see, as everything happened, the continued investigation and prosecution of just significant cases like the Goldman Sachs 1MDB case, where you have one of the most significant bribery schemes ever. The JP Morgan market manipulation spoofing case. We've seen the healthcare fraud unit do its annual takedown, but to be able to do it at the extent and degree to which they were able to bring as many cases as they did, this takedown had the greatest loss amount of any takedown in history. Seeing the units continue to do trials in the middle of everything. The Deutsche Bank spoofing case, where we convicted two Deutsche Bank bankers, as well as several healthcare fraud trials. So to see that happen in the midst of everything else is really, I think, just a testament to the tremendous efforts and work of the prosecutors.
Thanks, Dan. And before I turn to Jamie, let me just say one thing. I'm new at this particular interface, but I believe for everyone in the audience, there's a question tab, at least on my screen on the upper right. I think you have one as well. If you have questions for our esteemed panelists, please feel free to type them in. Please feel free to do that if you like. So Jamie, all yours.
Thanks, Jason. So probably the biggest difference between me and everybody else here is I don't have to give the disclaimer because I'm actually a month out of the job, so I can say whatever I want. And I guess
that's why we're excited to have you here. We really want you to let your hair down. You can't tell us all the things that Stephanie and Dan want.
Look, you're unemployed. You don't have to put on a tie like everybody else. So, look, I'm obviously thrilled to be here with everybody. And a month out of my job at the CFTC, have an excuse to shave and at least put on a jacket here. But look, I think you're gonna hear the same thing from all of us, and I expect if folks who are in the audience were asked what their most important or proud achievements over the last year have been, they'd also talk about the response to the pandemic. I think it really has been extraordinary, not just on the government side, we know on the private side also. Just give you, we may talk a little more about this, but I'll give you just a little bit of a sense of the way that we thought about it. At least, now we're 8-9 months into the pandemic, which is a little bit hard to believe if you try to put yourself back into the mid-March period. But at least for us, I sort of thought about it as having 3 different components. The first was, think about mid-March, at least in New York, where I live with my family. I was going back and forth to D.C. They're turning parts of Central Park into a makeshift hospital. They're bringing a military ship up the Hudson River. They're turning the Javits Center into a hospital. The first thing for us, I think, as an agency was trying to make sure that our staff knew that they were supported, to make sure that they were safe, to make sure that they were healthy as they were trying to navigate all these different obstacles, challenges, and anxieties. As Steph says, they're school teachers, they're caretakers, and of course they're also enforcement attorneys and regulators. But at least at the beginning, we wanted to make sure that everybody knew that we recognized and everybody else recognized there really was a human component here that had to take priority. But pretty soon, I think maybe April, we got to a point where we're monitoring the financial markets really closely, trying to make sure that we're providing tailored and appropriate relief to the market participants such that they could continue to operate and that we could avoid an awful public health and economic crisis turning into a financial crisis. And I think at least so far, and I'm knocking on wood here, we've avoided that. You get to April, and I think the question really was, how do you make sure that you're continuing to advance the mission critical functions and fulfill the mission critical functions that you're expected and really need to do? And I think I, like everybody else, have been really pleasantly surprised that the mission critical functions really did get fulfilled. The investigations continued, resolutions continued to get done, briefs were filed, court deadlines were met, interviews took place. It really, I think, was extraordinary on the part of really all of our staffs, and I think we got to recognize on the private side as well what an accomplishment that is, just to make sure that the work continued to get done. And the third thing, and we really turned to this, I think we probably started to recognize this in earnest in the July, August, September period. And if I were still at the agency, this is something that would be front of mind for me. Is it that at some point you've got to be a little careful that the work doesn't become purely transactional, and that it doesn't become in the total remote working environment where you don't have the 5 minutes before a call or the 5 minutes after the call, or you put the phone on mute and say, wow, that was a really good point, or can you believe this? Can you believe that argument? Or wow, how crazy is this person? How do you keep the kind of human element going, and how do you make sure you don't drop the common thread, or you continue to maintain the culture, the esprit de corps? And I think as we get farther and farther into the pandemic, I think that's something that as we get farther and farther into the remote working environment, and we get a little more confidence that the actual work is going to get done, but how do you do it in a way where it doesn't become impersonal, where you don't lose all of those things that keep the job from being purely transactional? And on that point, I'll only say I have a little bit of a hope that there may be a little bit of a silver lining here. I think I've seen, maybe at least when I was at the agency, I thought I saw maybe a little bit of an increase in the civility in the relationship between the government side and the defense side. Sort of recognition that we're all trying to work through this together. We had folks who asked, well, can we share? How should we be sending the exhibits before testimony? Is it okay if we rely on their representation that they won't look at them the night before, or whatever the point is, or can we hand them over to them so we can do a trial run before the remote hearing? And the answer to all those questions was yes. And I think we had total trust in the defense lawyers and the defense bar, and I think they had total trust in us that you would honor those commitments, and that there really was an effort to work through those things together. On the substance, we're gonna spend a lot of time tonight, I think, talking about the substance. We'll have plenty of time to do it. I think at the CFTC, like the other agencies, we have a lot to be proud of in terms of the substantive cases over the last year. And I think that would be true whether you're in a pandemic or not. But the fact that I think the agency was able to accomplish those things and our staff was able to achieve those results, I think is really a testament to the dedication and the commitment of the staff at the agency. I'll say more about this, but the agency filed more cases by a significant margin than it has ever filed before, and it filed the largest cases that it's ever filed. So you put those two things together, you add a pandemic on top of it, I think there's a lot to be proud of.
Those are all great points. I agree with all of that. I will say, if you figure out how to maintain culture remotely and how to, particularly to mentor and foster our younger attorneys, call me offline. I'd love to know. I think we're all struggling with that. And you're also right about your point about both sides feeling more humanized. You can see open, dresser drawers. You get to see like people's lives. It's all just very different. So I agree with that. Next question. So over the past couple of years, commentators have decried or applauded a decline in the intensity and volume of white-collar enforcement efforts. This is really a question not for you, Mike, so much, but for Jamie and Stephanie and Dan. Would you three agree that you've become sort of the Maytag repairman of government agencies with nothing to do? Or do you have a different view of your focus, your efforts, and your impact over the last few years? Let me start with Dan for this one, because he's big on my screen.
Well, I'm terrible at repairing appliances, so I think that's probably an inapt analogy. Look, I think you heard this in all three of our answers to the first question. From my perspective, the number of cases that we are investigating, the number of cases that we're initiating, and the significance and types of cases that we're bringing is at an all-time high. And so we have not slowed down what we are doing. And again, I agree with both Stephanie and Jamie that that's all the more remarkable given the pandemic. But really, what you are seeing is one of the most significant years in the fraud section's history in terms of the significance of the cases we're bringing. I mentioned the Goldman Sachs 1MDB case earlier, Airbus, certainly a number of market integrity and major fraud cases as well. And I think you're going to see that continue. You've also seen, in addition to all of that, a focus on Ppp related fraud coming out of the fraud section. And the minute that the CARES Act was enacted, we had a task force stood up and began investigating and prosecuting, and in really just 4 or 5 months' time, had announced 50 individuals, more than 50 individuals charged, which those of you who have been involved in prosecutions before understand how difficult it is to bring those types of cases that quickly. And so the dedication, the resources that we put towards that, understanding how significant that fraud is, taking money away from those who need it most in the middle of a pandemic. And then in addition to all of those things, we've come out with a number of policy revisions and policy announcements, updating the FCPA resource guide, updating the evaluation of corporate compliance programs. We also had the FCPA units of the SEC and DOJ, as well as the government writ large, had our phase 4 review from the OECD, which again is time consuming and very important and significant. So I think this year is truly a one of the high points in terms of the fraud section's history, certainly of white collar enforcement.
Thank you. You also presaged like 9 of my questions later, so that's perfect. That's very efficient. Stephanie, how about you? Do you want to agree that y'all just aren't doing anything? Do you want to address that?
Yeah, I mean, it's complete and utter fake news. And it's been a narrative that's been out there, as you say, for the last couple years. And, that narrative existed before I even started in this job, that's what this was going to be. And it hasn't been that. And look, that's true both if you look at the numbers or you look at the substance. No matter what you look at, it has been an aggressive, intense enforcement program with a substantial volume of actions. And, not only do the numbers not bear out the notion that it's been sort of a decline or the Maytag repairman. It's the opposite. I mean, the numbers show the opposite. And frankly, that's no surprise, right? I mean, it's the same SEC staff that's here, administration over administration, and they're working as hard and they're as dedicated as they were when they worked for, the last person and the person before them and the person before them. And that's what you see in the cases. You see them bring the same, us recommend to the commission, the same types of cases. And that's why you don't see wild pendulum swings in the enforcement program over time. I guess I'd say a few things. Not only, has it been an aggressive program, not only have the numbers been as high, the dollars this year was record breaking in terms of dollars, and last year was record breaking before this year was record breaking in terms of the dollars. I don't point to those things as indicators of a successful or a strong program. They just are. It's a factor, it's a measure, it's a thing, but people point to it. And so, it's a metric we look at. But not only did we do all that stuff, it's sort of interesting. Dan referred to a lot of policy things that were done. I sort of look at a lot of those things too. We did what we did in the face of great challenge, and every administration and every director who sits in my seat has had great challenge, and it comes in different forms. But, for us in the last several years, we had 3 huge Supreme Court cases. So, we had Kokesh, we had Lucia, we had Lou more recently. Each of those has required a massive amount of person power in responding to them in different ways, right? So we had that. We had a government shutdown for 35 days. We've had, obviously, the pandemic, and we had a hiring freeze. Last year, we had 150 fewer people than we had at the end of 2016. I mean, it's sort of, when you think about all those things and then factor in that we stayed, brought just as many cases, just as much money, huge changes in the whistleblower program, huge distributions back to investors, it sort of just belies the notion. And then finally, lest someone say, well, they're out there writing a bunch of traffic tickets so they can juice their numbers. No, that's not it. Take a deep dive in the cases. Doesn't support that. Look at just a handful of the stuff. We've brought, I'll point to some of the bigger and more notable ones, but like the Wells Fargo case, Facebook, Fiat Chrysler, Mylan, Tesla, Theranos, 1MD, the Goldman 1MDB. I mean, there have been a whole litany of Wall Street cases in having to do with ADR practices. There have been a whole litany of cases. And so, I'll end where I started, which is that's just fake news, Jason. So
I appreciate that answer. I will say that I'm not sure every director of enforcement before you has faced challenges. I think Mike's partner, Bill McLucas, thought everything was pretty easy and he handled it pretty well. So I don't know. That's just how that's what I think he would say. So Jamie, if Dan and Stephanie are busy, it must be you guys, right? You guys must be super bored and have nothing to do, right? You guys didn't do anything the last couple of years.
Yeah, exactly. I mean, look, I think, Jason, one thing that we should all keep in mind here is I don't think anybody up here on the regulator side or the enforcement side, or when I was sitting in the seat, is sitting there thinking we need to hit a certain number metric, we need to get to a certain number of cases, we need to get to a certain dollar amount. That's not how we think about it, and that's not how I think the public would want us to think about it. So you think about the CFTC. We've identified the same priorities year over year. We've published them in our annual report, protecting market and preserving market integrity, protecting market participants, promoting individual accountability, and enhancing cooperation with our domestic and international law enforcement counterparts. We added a 5th one, which is promoting and increasing transparency in our operations. And I think we've taken a number of strides to achieve that priority as well. But those priorities are the same year over year. They should be. As Steph says, you don't want an enforcement agency that's whipsawing or swinging like a pendulum back and forth. Investigations take time. They often span different administrations. They often span different sets of leadership, even within the same administration. And so I think one of the things you hear is a response to this question about, well, is there a certain amount of activity? And I just don't want to lose sight of the bigger point, which is that's not how we think about it. But at the same time, we're not going to sit up here and let somebody sort of lodge allegations that turn out not to be true. I think if you look at if you look at the record of the enforcement division of any of the three of us who are sitting up here, at least on the government side, it's really been an incredible amount of activity and productivity. I said this at the outset, but for us, most number of cases in the biggest cases. And these are cases that involve significant market activity. They involve significant types of misconduct or violations in our markets. They involve charges against individuals. They involve not just corporate resolutions. They involve parallel actions, many of which involve DOJ. Brought the largest, the biggest case in the agency's history in coordination with the states, filing it with 30 different state regulators. I mean, think about anything that you can get sort of the federal government and 30 states to agree on, sort of almost anywhere in our country right now, and we were able to bring everybody together to file a case to address conduct that we thought was really significant. And so I think when you pull all those things together and you really do take a deep dive, you realize that the concern that had been raised, I think, was really a narrative maybe 4 years ago that was in search of a story, and that story really hasn't played out in a way that would meet the narrative. The only thing that I'd add that I think may be a little unique to the CFTC is I do think that the CFTC will continue to have a decent amount of space to grow. I think the thing that makes the CFTC just a little bit different is the enforcement program and the policy side too, but thinking really specifically about enforcement, only 10 years into the post-Dodd-Frank CFTC world. Some of the regulations were written a few years after that, so even less than 10 years in. I think if you look at the history of the enforcement program post-Dodd-Frank, the first 3 or 4 years were really heavy rule writing, thinking about what the rules covered, what the actual laws and regs or requirements and regs would demand. Second sort of 3 or 4 years was starting to bring cases in those areas, many of them first of their kind, many of them sort of path marking cases leading to precedents that provided a little more clarity and a little more guidance about how those rules would apply in specific instances. And now I think that the terrain is a little more set. You see an opportunity within the CFTC enforcement division to kind of think a little more strategically about how the agency and the division would fill out the rest of that landscape. And I thought that was something that we had the opportunity to do over the last several years, and I'd expect there to be further thinking on that going forward.
But Jason, can I just say, from the perspective of the defense bar, I agree with everything that my colleagues have set up here. But there have been real shifts in priorities and policies that have been welcome to the defense bar. It's not that the enforcement agencies laid down and stopped bringing cases, but if I think back to March 2018, when there was a declination with disgorgement given to Barclays for its admitted illegal front running, that was a recognition that if a firm came in and the client had self-disclosed and cooperated and was really moving in the right direction, that would be rewarded, or at least not further punished. And that was a policy that I think it grew out of the FCPA world, but it really encouraged the defense bar. Later that year, when the DOJ announced their anti-piling on policy, that was also something that the defense bar had been up in arms about for a while. It was something that we often would perceive. We settled something with one agency to have another agency come in with the same allegations. And so it was really a meaningful change. Toward the end of that year, when the SEC and the federal financial regulators announced, and then in December 2018, DOJ amended the Justice Manual to the same effect to say that criminal and civil enforcement actions would only be based on violations of law and not on guidance. That was an important statement for the regulators and for the Department of Justice to make. That was reassuring to the defense bar. And then, even if you fast forward to this year, the guidance that the regulators and DOJ have given in updating their evaluation of how they evaluate corporate compliance programs this summer or the update to the FCPA resource guide. Things like that have added to our ability to advise our clients how to obey the law, how to be compliant, and that if they find something in an internal investigation that's problematic, the knowledge that we can walk it into a regulator without the fear that we're going to be punished for doing the right thing. Those were all important changes, I think. And so it isn't that to my view, this administration didn't lie down on enforcement, but it did listen to corporate America, and it listened to the defense bar, and it made some changes that have been impactful.
Thank you. I agree. That all makes sense to me. I agree with that. I also just want to note, Jamie, really nice use of the word path marking. That's a nice homage to a recently departed justice. I think that was her favorite word. That's very nice. All right, let me turn to the next question if I can. It appears that Joe Biden will be inaugurated on January 20th, it appears. Two of your agencies have also recently experienced or are about to experience substantial leadership change. Jay Clayton has announced that he'll step down as the chair of the SEC at the end of the year, and Jamie, you left the division, the leadership position of the Division of Enforcement at the CFTC. And there are tons of webinars like this where everyone wants to know what's going to happen come January 20th. I watched one earlier this week with Mary Jo White and Joe Grunfest and Robert Jackson opining, and they're much smarter than I am and much more, much more insightful. And they were all still just guessing. They're like, I don't know, this will happen the first year. This will happen year 3. Who knows? I think our audience would love to hear from your perspective. And Dan and Stephanie, maybe since you're in, you can't really let your hair down, but Jamie, let it all out since you're now, you're a free agent. They'd love to hear from your perspective what changes in approach and priorities and resources or otherwise that new leadership may bring. I have a sense of how you're going to answer based on how you just answered, but let's go ahead and ask it. So Jamie, let me start with you because you can be the most sort of unfettered. Tell me how it's going to be different come February of next year.
Yeah. So look, I think anybody who's expecting a significant change is going to be disappointed. I think if you look at the enforcement, if you look at the path of enforcement over the last couple decades, I think you probably see more of a straight line than a bunch of huge shifts. So, Mike, your point about the changes that you've seen over the last 4 years, I think those are significant changes. But that's not because I came in as director and said, okay, here are the 4 or 5 things that we need to change, or we had a chairman or particular commissioners who said, okay, let's make a hard pivot here to start listening to points from the defense bar or to start trying to figure out if we can come up with components of our enforcement program that are a little more right-sized or that may make a little better sense. I think it actually is just a continuation of a trend that you've seen. Really, if you go back 20 years, the way that, for example, undertakings or remedial requirements were happening in corporate cases 15 years ago, they were significantly more onerous. So the complaint at that point was you've now got prosecutors in the boardroom. You've got prosecutors requiring structural reform through the remediation and the undertakings. And I think there was a little bit of a response to that. And you go 2005 to 2010 or 2012 or so, and there was sort of there was a significant effort to have the remedial efforts and the undertakings much more tailored. There also was a discussion around that time about how do you balance corporate accountability and individual accountability? How do you ultimately get to the deterrence that we're all trying to achieve? Point here isn't really to just bring cases, it's to affect behavior in a positive way. It's to try to get more people in compliance with the law. And I think there was a recognition then in the next phase of it that individual accountability had to sit at the center of any significant enforcement program. And I think that was also the result of an ongoing dialogue between the regulatory and the enforcement world and the market participant side. And I think you've continued to see that sort of a discussion and dialogue take place. I think that's good. I think you should have regulators and enforcement officials who are thinking about how their enforcement program can be more effective, not just from their perspective, but from the market participant side. That doesn't mean that the market participants are going to get everything that they want. And I certainly don't think that the market participants would get everything that they want in a Biden administration. But I do think that it's reflective of the fact that at least if you go back 15 or 20 years, there has been a bit of this dialogue. And I think there's been a consistent refinement of the way that the enforcement programs have operated that's for the better. I think everybody who's sitting here as part of this, at least on the government side, who's sitting here as part of this panel would take great pride in the policy advances or policy objectives that their agencies have implemented or their divisions have implemented under their leadership to move the ball forward just a bit. But I just don't think there's going to be a pendulum shift in the other direction. Now, absolutely, the administration will come in and the leadership of the different agencies will come in and they'll set priorities that could be different in one direction or another in some ways from the current priorities. I'd expect those, whatever those differences are, to be a bit more modest than folks are likely anticipating. And I'd also expect them to be based not on some preconceived notion of we got to get more enforcement in this area or we've got to get higher penalties in that area, but actually based on a holistic view of what the mission of the agency is, where that mission might be advanced in certain respects, and where enforcement might be an effective tool to advance those components of the mission. And look, I think one of the things that you'll see is people coming in and adding a fresh perspective and identifying new points that they think should be added to the agenda or modifications to the agenda. And I think that can be a healthy thing for organizations over time. So it'll be interesting to see. I wish I had some grand insight.
So do I, Jamie.
Which I could share with you, but I think it'll ultimately be a bit more modest than folks are predicting.
Let me pose the same question to Stephanie. I will take any general observations you have and one in specific that I'd love for you to comment on if you can. So during Chair Clayton's tenure, there's been a marked sort of sustained focus on Main Street and protecting Main Street, which shows up a lot in your annual report for the Division of Enforcement, and it sort of colors a lot of the sort of public statements about it. If Biden is inaugurated on January 20th, do you expect that focus to continue under the new leadership coming in the next year? Do you see a rhetorical or a resource or focus shift towards additional scrutiny of Wall Street? How do you see that playing out?
I mean, I sort of echo a lot of what Jamie said. In fact, all of what Jamie said. There are always going to be some changes. There are always going to be things you can do differently. And every chairman has their own priorities that they come in with. And so might a new chairman come in, with a similar focus on the protection of, Main Street investors? Absolutely. Might it be the same or as sharp a focus? It may not be. It may be that a new chairman has other priorities, but every chairman, certainly every chairman I've ever worked with and every chairman I've ever observed from afar, cares about retail investors and cares about Main Street investors. And I think the amount of resources and the degree of focus may shift around the edges. And certainly it was a central component of Chairman Clayton's tenure, and it's been a central component of what we've done in the Division of Enforcement. But, if you walked around the Division of Enforcement and stopped in any random person's office, everybody was focused on this issue. This was a great opportunity for us to really take some resources and focus them in some more direct ways, which I think will have lasting benefits. And I'd be surprised if anyone really moved away from that. But I think, where I started, every chairman comes in with their own priorities, both enforcement and regulatory. And I would expect the new chairperson to do the same.
Okay, Dan, tell me about the wholesale changes that are about to come to the fraud section of the Department of Justice in about 65 days.
Yep, and I've got my list here, and it's broken down by 6-month increments, so I can reading off. Look, I obviously agree with everything folks have said. The fraud section is made up of the career prosecutors who continue to prosecute white collar crime. I think you have seen that steadiness over multiple administrations. I know Michael spoke about a number of policy initiatives, and I think those policy initiatives have been pursued sort of across administrations. Certainly the anti-piling on policy grew out of really the FCPA unit's practice in 2016. With a slew of coordinated multinational, multi-jurisdictional resolutions. The corporate enforcement policy grew out of the pilot program, which cut across administrations. So I think you see a recognition across administrations about the importance of the work that we are doing. I think you see a recognition of the importance in transparency, both in treating corporations and individuals fairly, but also in pursuing enforcement goals. And so I fully expect to see continued enforcement in the way that we have in the fraud section. That's one of the nice things about being in a career office where career prosecutors pursue justice.
So Jason, having had the three of us sit up here and give you no specific answers, I feel some obligation as the only one outside the government to try to give you some specificity.
Let me have at it.
Let me give you two, at least with respect to the CFTC. I think that, and I should say, I think these are more sort of organic developments that have been underway for some period of time, but you may see the fruits of over the next few years. I think you're going to see increased enforcement and attention in the swap space, particularly as you think about this being a market that was not fully regulated until Dodd-Frank was passed. It's hundreds of trillions of dollars in notional. The agency has been writing rules. It just within the last year passed revised swap data reporting rules. I think as the data continues to get better and as the agency continues to fill out its landscape or continues to fill out the terrain, both on the policy side and on the enforcement side, I think that the swap space is going to be an increasingly important space for the CFTC. And the second is, I think, internationally. If you go back to the LIBOR cases, that the agency is just, and I think the market has recognized that the commodities and derivatives markets are just totally interconnected, and they're globally interconnected. And so I think really is something that the agency has done for a while now, but sort of then I think went into a whole new realm with the LIBOR cases and the FX cases and other benchmark type cases. I think you'd see a continued development and emphasis in the international space where there's a connection to the U.S. derivatives markets.
Thank you, Jamie, for a little bit of clarity. And I'm just kidding. Thank you for everybody, all of you. Mike, from your perspective, what would be most helpful for an incoming new regime, new administration, and what are you most apprehensive about?
Well, there's really two answers to that. I mean, what's most helpful for my clients is kind of the opposite of what's most helpful for me as a defense attorney personally. I think there is what we're most apprehensive about. There's a fear that there will be a renewed, perhaps a bloodthirst for banks. I think there is a fear that when people think back about the time, I think people conflate the feeling that was the zeitgeist, what you were reading about in the papers after the financial institution crisis of 2008 and 2009. And when people were saying, why aren't more bankers in jail? People conflate that feeling of, well, we have to get back at bankers because of the financial crisis with this idea that a Democratic administration is just going to be anti-financial institution. And I think we're a long way from the financial crisis, and it's a different world now, and that fear is not wholly justified. But I don't think it's entirely made up out of whole cloth either. I think there's a real worry there. One thing that a lot of my clients would like to see is more certainty in the regulatory space regarding sanctions, almost the way that there was a guidelines that were imposed at DOJ where you could tell if this is the charge, this is what the penalty is going to be. Now, the guidelines aren't binding anymore, but it was almost a mathematical degree of precision where you could say this is what the range was. But regulators, and I'm not to call out the SEC or the CFTC in particular, but across the board, regulatory agencies, some have guidelines for their imposition of sanctions, and some have factors. They're going to, the sanction is this amount per violation or that amount per day. Some have very detailed sanctions books for each type of violation, this is what the sanctions can be. But in my experience, pricing what the penalty is going to be for a violation is like at Sotheby's pricing whatever a Rembrandt is going to sell for. like, you know that your penalty is going to be more than whatever the last penalty for this thing was, because every case, every year, there's going to be a new record FCPA case or a new record anti-money laundering case or what have you. But how much more is very hard to say. And I think some degree of precision or some constraint to that kind of penalty inflation would be helpful from our perspective.
Thank you for that. Do any of the recent government folks want to respond to that, or we can move on if not? Anybody? Okay, we'll move on. We only have about 14 minutes. This has gone really fast, and I'm having a great time. I hope you guys are as well. I want to turn to something that Stephanie alluded to earlier, which is about whistleblowers. So you all rely on whistleblowers. The SEC's Office of the Whistleblower had a just gangbusters record year. I'm curious. I'm going to start with you, Stephanie, and then I'll turn to Jamie and Dan. What sort of prompted the increases, and do you think the pandemic has affected the number or the quality of whistleblower tips? And you mentioned, I think, at the outset that the Office of Whistleblowers become more efficient. I'd love to hear more about that and where you think that's going to go and what we can expect.
Yeah, there's a ton going on in the whistleblower space, and the Commission implemented new rules to the whistleblower program in the last few months as well. They're about to become effective, which are also designed to further increase efficiency and clarity around the program, and I think will also really help us get stuff done faster. So a couple things in there. One, our tips, complaints, and referrals were up substantially last year. I think we closed out, I want to say we closed out at over 23,000 tips, complaints, and referrals in 2020, fiscal 2020, which is a substantial increase over prior years. I don't remember how much of an increase it is for the whole year, but I know when I looked at March to the end of September, it was like a 70% increase over the same time period the prior year. So clearly there's some piece of that is tied to COVID. Now, those are all tips, complaints, and referrals. The subset of that are marked as whistleblower tips are roughly 30%, and that percentage has not changed. So the year before it was roughly 30%. It might be 31, but it's right in there. And so what that tells us is the percentage of overall complaints are roughly the same, but the sheer number is clearly going up. Why is that? I've had lots of people ask that question. I've spent lots of time thinking about it. I don't know. It's clearly tied to COVID, and I've heard all kinds of theories, all of which make sense, right? People are seeing stuff at their place of business that, stuff that was perhaps previously masked is becoming unmasked because of market volatility and other issues, surrounding the pandemic. People are home and they're more disaffected and they're more disconnected and they feel more comfortable reporting things because they're home. People lost their jobs and are more comfortable reporting things. Problems have gone up. I've heard all sorts of theories. I have no reason, no basis for pointing to any one or all of them as the actual reason, although they all make sense. And the one thing I think you can take away is, given that this dramatic increase, lines up completely with the pandemic on a timeline, there's clearly a relationship there. What it is and how it works together, don't know. I don't have a strong sense at this point on what is the quality level of these tips, right? Is it, are they all high quality? Is there a substantial number that are not meant for the SEC, that are meant for someone else, that are, not good tips? That I don't really have a sense of. I've publicly said we've opened roughly, maybe a little more than 150 COVID-related investigations. I don't have a sense of whether and to what degree they're tied to those whistleblower tips. I just don't know. I know we did a lot of that proactively. I assume some is tied to it, but these are all analyses we haven't done, but I think they're all good questions. And there's certainly questions that are raised by these tips, by these increase in whistleblower tips. In terms of the program, about 18 months or so ago, we sat back in enforcement and undertook a process of saying, what, if anything, can we do to increase the speed with which we are considering award applications, award claims, and getting them out the door, either as an award or as a denial, whatever it is. And, when you look back, the program was set up 11 years ago, whenever, on the back of Dodd-Frank. And it was, set up at a time where you didn't have any whistleblower claims. And it was set up really to be a very perfect, very thorough system. And I think, it has been wildly successful in terms of tips, in terms of claims, in terms of awards, all those things. And so we really did take a step back and say, what can we change? What can we make more efficient? How can we leverage resources across the division? How can we do these more timely? And we made a lot of changes in the process to really speed it up. And I think, it took some time to implement it all, but we've really seen the fruits of it, particularly over the back half of fiscal 2020. We see it already in fiscal 2021. I think we've certainly awarded somewhere between 5 and 10 awards in the last month or so. It might be like 8 or 9. Some have been significant. One is the highest award ever. So there was a $114 million award to a single whistleblower, or I think it was one award. And that's the highest we've ever done in the program. So, these are really, there's a lot in the queue. We're going to continue getting them out quickly. And so I take great pride in it. We awarded the awards we put out in 2020, I think, far eclipsed the last most productive year. I think the last 3 years, or the last 3 of the last 4 years, were the most, awards, which makes sense. It took the program some time to get going. But last year, we got out 30 some awards, which is more than, I think, a 200% increase over any prior year. And so I would expect to just see that continue. And now with the changes to the whistleblower to the recent rule changes, I think will make it even more efficient. One of the rule changes is, just in sort of shorthand, is for any award where the possible maximum amount of the award is $5 million. There are a list of positive and negative factors that are to be considered in determining the amount of an award. If there are no negative factors present, with a couple of potential exclusions, there's now a presumption that the person should get the full amount of the potential award, the full 30%. And that will take out a lot of the analysis, I think, on a lot of these awards, which will get them out the door faster.
So that was incredibly illuminating. And offline, I want to talk to you. The real question I have is how I can get into the $114 million whistleblower category. I like practicing law, but not $114 million much. I could certainly find something else to do. Jamie, anything you want to say about the CFTC, their use of whistleblowers, what's happening, what's going to happen?
Yeah. The only thing I'd say is, 1, share Steph's sentiments. 2, share Steph's sentiments about the value of the whistleblower program and the value of whistleblowers. 2, I do think that it's a space that you're going to continue to see in the SEC, on the SEC side, as Steph just said, but also on the CFTC side, as continuing to expand. If you think about running an enforcement program and the components of an effective enforcement program, everybody knows that if you can get an insider to discuss what's happening on the inside and to provide an inside perspective, that is absolutely invaluable for building an investigation. A number of us here are former or current federal prosecutors. When I was at DOJ, you had to actually charge somebody, and then you had to build the case to charge somebody, and then you had to convince them to become a cooperating witness so that you could have that inside perspective. I think it's a tremendously powerful tool to be able to have another avenue, which is through the whistleblower program, to provide that to provide the agency and the staff with that inside perspective. So I think everybody in the enforcement world recognizes what a powerful tool it is. We're all thinking about ways that we can continue to grow it responsibly, and in particular expedite the review of the awards, because we recognize that whistleblowers are making decisions about whether to come forward or not, and part of that decision-making process is timeliness and certainty with respect to the awards. And so we want to provide the right incentives to continue to develop the program as it should be developed.
Thanks for that. Dan, this is going to be a snake draft. I'm going to give you 2 questions in a row. So I want to start with the whistleblower first. So you mentioned the OECD Phase 4 report that came out. It got published earlier this week. And while it was generally quite laudatory of the department and the SEC's enforcement of the Foreign Corrupt Practices Act, one of the areas of constructive advice for improvement for the U.S. government, which will really fall to the department, is a whistleblower program for employees of non-issuers, akin to the robust one that Stephanie just described for issuers. What do you think of that? Are you guys going to do it? I'd love to know what's happening with the DOJ's, I'm sure, gestating whistleblower program.
Yeah, and I think we were certainly very happy with the report. I think it addressed a number of enforcement efforts that we've undertaken over the past 10 years. And one of the great things about the OECD and why it is as effective as it is, in my opinion, is because they have these phased reviews and peer reviews of other countries. And so, look, there were several recommendations that they made, and I think we are obviously going to try to meet all of those recommendations. And I think ensuring that there are whistleblower protections, that we are encouraging whistleblowers to come forward and that we're protecting them when they do, I think is very important. And it's something that we can all strive to do better. And I think we are going to be looking at that and seeing what we can do to encourage it.
Okay, thank you. And let me give you again the back half of the snake draft question, the second question. So Mike mentioned earlier the anti-piling on policy a couple of times as a salutary development in recognizing a concern the business community had. There's a recent FCPA resolution last week, 2 weeks ago, with Jim Beam that is, I think, largely for the same conduct that the SEC resolved with the company 4 years ago. And there's a mention in the resolution documents of the department that they're not crediting. You all didn't credit the previous SEC resolution. Would love to know why, what the business community and the white collar defense bar can take away from that and lessons learned going forward.
Yeah, no, absolutely. I think that's a great question and an important one. We are, particularly, as I said, the anti-piling on policy grew out of the FCPA unit, and I think the FCPA unit and the fraud section more generally has been very consistent and in applying the anti-piling on policy to ensure that companies that are trying to coordinate with various authorities don't pay duplicative penalties. And I think what you have seen over time consistently is that even when companies try to coordinate, but through no fault of their own, the various authorities are unable to reach a coordinated resolution in terms of timing. The DOJ, I think, has been very good about crediting resolutions. So, for example, in SBM, despite the fact that the Dutch resolved with the company several years earlier, we still credited a portion of that. Brazil was resolving several months later after our resolution. We were still able to credit that. And you see that across a number of resolutions. What that doesn't mean, however, is that if a company tries to silo off different agencies for strategic reasons and tries to get a favorable resolution with the SEC while at the same time refusing to resolve with the DOJ, that in that type of a situation that we will credit if we later put together a case and the company understands at that point that we are prepared to move forward with our prosecution, and then the company ultimately comes around and says fine, we'll resolve, that we will then go back and credit a penalty that they reached strategically with another agency. And so I think what I would just encourage, I think we've said this before, I've certainly tried to say it before, and I'll say it again now, is if a company is looking to get crediting for resolutions, then they need to play a part in the coordination as well. There's certainly a very large part and role that the department and the other foreign authority or domestic authority plays, but the company plays a role in that as well. Okay, got it. That makes a ton of sense and is very helpful for the Mikes and the me's of the world to take back to our clients. So we're at an hour, and I am told there are hungry children waiting who don't want to have this go much longer. I'm happy to wrap up, but before I do, I just want to make sure that I give anyone an opportunity. If there's anything else you want to say to our ABA audience, let me go. Stephanie, anything else you want to say as a concluding remark? If not, totally cool, but I want to make sure you get a chance.
No, I appreciate the ask. Thanks for having me, and sort of echo everything that Dan and Jamie said as well. So I think we've covered the landscape.
Great, Jamie.
Me too. Thanks to everybody for having me, particularly a has-been like me.
Like I said, you're the freest to share. We were excited to have you join. Dan, anything else?
No, just thanks so much. It was certainly a pleasure to do this. So thanks so much.
Our pleasure. Mike, last words?
Sure. I mean, I recognize, and it's good to hear you all commend your staffs for how heroic they worked during the pandemic. And I also want to thank you all and your staffs for the kindness and graciousness that they've provided to people in the defense bar, because we and our clients have also been struggling with, trying to practice law from home, trying to move all of our businesses. Businesses are all moving from home, and there's just been no lack of graciousness and charity in terms of time extensions, and we can't get this document, we can give you that instead. It's been very helpful. So, on behalf of the defense bar, thank you.
Michael, can you let me know who's giving you extensions? Because I'd like to make sure that they're not too long. No, I'm of course kidding. And look, that is, we are certainly very glad to hear that, and that is certainly one of the things that we think is important and know that our prosecutors recognize as well. So thanks for saying that.
Great. This was an utter pleasure. Thank you all for joining us, and let's do it again soon. Thanks so much.
Thanks.
Thanks.
Bye.
Thanks, everyone.